Assalamualaikum warahmatullahi wabarakatuh and very good morning to Doctor. Our group members want present about our group assignment. The title group assignment is Trespass to the State Line. First of all, I want to introduce our group members. Firstly, myself, my name is SITI binti ZAINUDDIN, and the second member is MUHAMAD AZIM bin ALIAS. The third member is UMAIRAH binti IHSAN. The fourth member is FAZILLA binti ABDUL GHANI, and the last one is NURUL SYAZWANI IZZATI binti MUHAMAD AZAM.
Next, let's continue. Introduction for trespassing of land. Unjustifiable intrusion by a person upon the land in the possession of another. Next, living on another's land without permission, refusing to leave after permission has been withdrawn, or placing an object upon the land without permission can constitute trespassing. In this context, land included premises like houses, shop lot, and occupied or vacant land. While state land is land owned by the government of the country or territory, including land under the high water mark and admiralty reserve, but does not include local authority-owned land. Hello and good morning. My name is UMAIRAH binti IHSAN and my matriculation number is AP210364. I will go on to discuss case law 1 and introduction. Let's start. Next, case law 1 facts. The plaintiff director found a chain of name from plaintiff to spec development and construction Sindrian Berhad, that is third defendant, chain of name in the register of land title and the registration of the transfer from the third defendant of Tu Chua and Tu Tan, that is transfer, and first and second defendant. It is claimed that the first and second defendant also received a new computerized ITT. Computerized ITT to the first to a third defendant, the director of the third defendant, that is fourth to the sixth defendant, and the registrar of title, the state of Selangor, seven defendant. They do not qualify as bona fide buyers for valuable consideration under the National Land Code NLC. And as a result, they are not covered by the provision to Section 340, Section 3 of the NLC. The plaintiff also filed suit against the seven defendants for negligence and violation of the law. The seven defendant is the Selangor State Registrar of the title, and his office is responsible for maintaining efficient and accurate land registration detail. Next, issue. The issue is whether the suit filed by the plaintiff against the seven defendants is prevented by Section 2A of the Protection of Public Authorities Act 1994X, whether Section 5 of and 6 on the Government Proceeding Act 1956 apply, whether the seven defendant has breached his statutory obligation under the National Land Code and is therefore negligent when he registered the chain of plaintiff name to the name of the defendant. Some of the first and second defendants are entitled to claim damages from the seven defendants for the losses suffered by them in the purchase of the land. Discussion. The High Court judge is understood to have ruled the registration of the name change invalid and should be waived, as there is solid evidence to show that the registration was carried out through false document and fraudulent means. The issuance of computerized IDT to the third defendant while the original IDT manual is still in possession of the plaintiff clearly in violation of Section 8 of the NLC for schedule the name change is null and void. The claim of the first and second defendant against the seven defendants are based on tort negligence. They are entitled to damages. Judgment. The High Court judge found there was solid evidence to show that the register of the name changed from the plaintiff name to the name of the third defendant was done falsifying document and it's a deceptive manner. The charge in the registration of the chain of name of the land from the plaintiff to the third defendant, the judge ruled that there was negligence and breach of statutory duty by the seventh defendant in the registration of the chain of name of land from the plaintiff to the third defendant.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti binti ZAINUDDIN and my menstrual number is AP210021. I will continue this presentation with second case, which is Kerajaan Negeri Selangor versus Sago Bentasi and others. This case occurred in 2005. The issues of this case is that the plaintiffs were evicted from the land by the defendants for the purpose of the construction of an expressway. The plaintiffs were Aboriginal peoples of the Temuan tribe settled on the Bukit Tempoy lands, and they brought an action against the four defendants. The first defendant is the state government of Selangor. The second defendant is a limited road construction company. The third defendant is the Malaysian Highway Authority, and the fourth defendant is Government of Malaysia for several declaration, composition and demands in relation to the acute deprivation of their land. The High Court granted the plaintiff compensation under the National Land Code 1960 for deprivation of land found to have been held under the customary title. The defendant appealed. They denied the existence of the regular community title not permitted under the 1954 Act and maintained that compensation should have been in accordance with Section 11 and 12 for 1954 rather than 1960 Act. The judgment for this case is the appeal from defendant was dismissed. The order of the court are set out in paragraph 70 of the judgment, and an award of exemplary damage against the second and third defendants were appropriate on the evidence of the oppressive treatment received by the plaintiffs. The judgment went out based on, first, the common law recognized the existence of customary title in the plaintiffs. On the evidence and finding of fact, there was no doubt that the plaintiffs had ownership of the land in question under a customary community title of a permanent nature. The definitive position at the common law was that the radical title to land vested in the state could be burdened by a native or customary title. The nature of customary title depends on the practice and usage of each individual community to be ascertained on the evidence as a question of fact. Furthermore, since the plaintiffs were occupying their land under customary right recognized by the 1954 Act, when compulsorily deprived of their land, they were entitled to compensation in accordance with the principle laid down by Malaysian court under the 1960 Act. By adopting a liberal interpretation, the trial judge was merely giving full effect to Article 8 5C of the Federal Constitution, which sanctioned positive discrimination in favor of the plaintiff. The plaintiffs were plainly entitled to a declaration that they also had customary title to unguested part of the land for which compensation was also under the 1960 Act.
Assalamualaikum warahmatullahi wabarakatuh. My name is FAZILLA binti ABDUL and my meeting number is AP210485. And next I will explain about the case 4, which is SITI and others versus the government of Perak. issue of this case is whether the appellants as squatters have a cause of action against the respondents, which is the state government. In this case, the appellants came to Teluk Intan Perak in 1950 and opened up a large part of a jungle area, then occupied that area and now known as Kampung Gajah. Other settlers also settled in that area. After that, the government resettled some settlers to the land that the appellants were occupying. The appellants were given notice to vacate the land. The appellants claimed that they were entitled in law and equity to possess the land that they occupied. Next, for appellants' grounds of support, in January 1977, there are a meeting between the appellants and the government. The district officer had promised them 3 acres of paddy land subject to successful interviews, while the Utusan Malaysia published an article stating that the State Director of Lands and Mines promised each pioneer settler 5 acres of paddy land. However, some of them, including the appellants, were unsuccessful and they were given the notice to stop work and vacate the area. Therefore, the appellants had filed a writ to obtain a declaration that they are entitled in law and in equity to be in possession of the lands that they occupy. In this case, the appellants came to Teluk Intan Perak in 1950 and opened up a large part of a jungle area, then occupied that area and now known as Kampung Gajah. Other settlers also settled in that area. After that, the government resettled some settlers to the land that the appellants were occupying. The appellants were given notice to vacate the land. The appellants claimed that they were entitled in law and equity to possess the land that they occupied. Next, for appellants' grounds of support, in January 1977, there are a meeting between the appellants and the government. The district officer had promised them 3 acres of paddy land subject to successful interviews, while the Utusan Malaysia published an article stating that the State Director of Lands and Mines promised each pioneer settler 5 acres of paddy land. However, some of them, including the appellants, were unsuccessful and they were given the notice to stop work and vacate the area. Therefore, the appellants had filed a writ to obtain a declaration that they are entitled in law and in equity to be in possession of the lands that they occupy.
Assalamualaikum warahmatullahi wabarakatuh. My name is NURUL SYAZWANI IZZATI binti MUHAMAD AZAM. My metric number is AP2102X7. So today I would like to continue the presentation with the case number 3. It is about Adong bin Kuau and others versus Kerajaan Negeri Johor and others. In this case, the state corporation had entered into an agreement with the government of the Republic Singapore to construct a dam and supply water to both Singapore and the state of Johor. The plaintiff are family heads representing a group of Aboriginal people living in the Sungai Lingyu catchment area, which includes the tributary Tebak. The defendants in this case are the Johor State Government and the Director of Land and Mines in Johor. The issue that arise in this case are whether all acquisitions of proprietary rights must be compensated and whether Aboriginal people are entitled to compensation for loss of livelihood and hunting grounds. The judgment of the court addressed 3 parts of Aboriginal people's rights. First, common law rights. Second, the Aboriginal People Act of 1954. And the last one is the Federal Constitution. In their affidavits, the plaintiffs are a group of Aboriginal people claim that the grounds around Sungai Lingyu were their ancestral territory. on which they relied to forage for a living in line with their custom. The plaintiff then alleged that the defendant alienated from the state corporation 53,273 acres of their ancestral land. Another issue that arises in this case is this compensation for orang asli land is not for the land itself, but only for the dwelling and trees. According to the common law, the plaintiff have established that they have proprietary rights over the Lingyu Valley and that the defendant have violated these rights. Section 11 of the Act guarantees adequate compensation for alienated land containing rubber or fruit trees claimed by Aboriginal people. The land on which the trees were planted was either Aboriginal reserve land or a forest reserve. Even if the land is purchased for public use compulsorily, sufficient compensation is required under Article 13 of the Federal Constitution. According to common law, recompense for orang asli land is solely for the home and trees, not the land itself. The plaintiff have proved that they have ownership rights over the Lingyu Valley, which have been infringed by the defendant, because the defendant had failed to show the authority to deprive the plaintiff of their property rights over the Lingyu Valley. To sum up, the 16 plaintiffs were granted to 26.5 million ringgit Malaysia in compensation under Article 13, Section 2 of the Federal Constitution. However, the plaintiff do not receive complete justice in this case. The amount of compensation awarded to the plaintiff was far insufficient in comparison to the 320 million ringgit Malaysia awarded to the Johor government by the Singapore government. The compensation paid by the Singapore government to the Johor government was solely for the Johor government's loss of use or revenue on what is above the land, not the land itself. And that's all for me. Thank you.
Now, I would like to talk about the conclusion for this assignment. It's about the trespass to land. Now, I will explain about the conclusion in this assignment. Trespass to land happens when one individual enters or resides on another's land without authorization or sets or project any item on the land, entering the land, refusing to leave the land after being asked onto it, causing another person to enter the land, causing an item to enter the land, or failing to remove his personal belonging from the land. And about the land, it might also refer to anything connected to the land, such as building, trees, and flagpoles. Thank you for listening about my explanation about the conclusion.